In 1878, George Reynolds was charged with bigamy after marrying Amelia Jane Schofield while still married to Mary Ann Tuddenham. Mormons were opposed to the Morrill Anti-Bigamy Act at the time because they believed it violated their First Amendment rights. Can religious duty be considered a defense? The court unanimously affirmed Reynolds' conviction. They argued that the First Amendment covered opinions, not actions. They were afraid that if they did not affirm the convictions, people could use religion to justify any actions such as human sacrifice, and religion would become above the law. It kept certain actions from being justified by freedom of expression. There should be limits to protect Americans from individuals who take advantage of their rights and push them as far as they can. This decision provides that limit.
Reynolds v. United States impacted public policy in that religious duty cannot be used to defend certain actions in court. Also, the Morrill Anti-Bigamy Act was upheld as well as other anti-bigamy and polygamy legislation.
A Jehovah's Witness was expelled from his high school for not saluting the flag. They then sued the school because they believed that their First Amendment right was violated. The Jehovah's Witness religion bans its members from saluting or pledging to symbols. Can a student be forced to salute the American flag? The court ruled in favor of the student, meaning a school cannot force any student to salute the American flag. The court stated, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or any other matters of opinion, or force citizens to confess by word or act their faith therein.
Policy that has been impacted by this case is the overturning of Minersville School District v. Gobitis.
Public schools in Illinois set aside class time for optional religious instruction. Vashti McCullum sued the school because her son, an atheist, was being ostracized for not attending. Can a public school's tax-supported facilities be used for religious teaching? Justice Hugo Black stated, "To hold that a state cannot consistently with the First and 14th Amendment utilize its public school system to aid any or all religious faiths or sects in the dissemination of their doctrines and ideals does not manifest a governmental hostility to religion or religious teachings. For the First Amendment resets upon the premise that both religion and government can best work to achieve their lofty aims if each is left free from the other within its respective sphere."
As a result of this case, policies did not allow tax-supported facilities to host religious instruction.
In 2000, a Texas school district allowed students to give Christian prayers over the speakers at home football games. The school system gave the students a vote after having some complaints, and the students voted in favor of prayers. Two anonymous mothers, referred to as Doe, sued the school district to get rid of the prayer. Does student-organized and student-led prayer in public schools violate the Establishment Clause? The court ruled that the policy allowing student-run and organized prayer in public schools is unconstitutional. The ruling stated that prayer delivered on school property at school-sponsored events over the school's public address system by a speaker representing the student body under the supervision of school faculty and pursuant to a school policy that explicitly and implicitly encourages public prayer are not private but public speech.
Policy allowing student-run and organized prayer in public schools was overturned because it was deemed unconstitutional.
The Affordable Care Act, Obamacare, stated that employers must provide coverage for contraceptive methods for female employees. This is a controversial and largely opposed mandate. The owners of Hobby Lobby do not believe in contraception and refuse to provide coverage for contraceptive methods for female employees. Does the contraceptive mandate within the Affordable Care Act violate the Religious Freedom Restoration Act? The contraceptive mandate is unconstitutional under the Religious Freedom Act. An employer cannot be forced to provide services that are against his or her religious or personal beliefs.
As a result of the case Burwell v. Hobby Lobby, the contraceptive mandate was removed from the Affordable Care Act.
A New Jersey law allowed reimbursements of money to parents who sent their children to school on buses operated by the public transportation system. Children who attended Catholic schools also qualified for this transportation subsidy. Did the New Jersey statute violate the Establishment Clause of the First Amendment as made applicable to the states through the 14th Amendment? No. A divided court held that the law did not violate the Constitution. This case is significant because it showed that privileges can't be withheld from those attending a religious institution. No, the court held that permitting payment of allocated funds for 1970 through 1971 school year would not substantially undermine constitutional interest at stake.
This case impacts policy due to the fact that laws that appeal to both secular and non-secular students can be made.
The Board of Regents for the State of New York authorized a short voluntary prayer for recitation at the start of each school day. This was an attempt to diffuse the politically potent issue by taking it out of the hands of local communities. The blandest of invocations reads as follows: Almighty God, we acknowledge our dependence upon Thee and beg Thy blessings upon us, our teachers, and our country. Does the reading of a non-denominational prayer at the start of the school day violate the Establishment of Religion Clause of the First Amendment? Yes, neither the prayer's non-denominational character nor its voluntary character saves it from unconstitutionality. This case affirmed that religious exercises cannot be forced upon school children.
This case bars schools from implementing religious practices and prevents government from making laws regarding the establishment of religion.
Alfred Smith and Galen Black worked at a private drug rehabilitation clinic. The clinic fired them because they used a hallucinogenic drug called peyote for religious purposes while worshiping at their Native American church. The Oregon Employment Division denied them unemployment compensation because it deemed they were fired for work-related misconduct. The Oregon Court of Appeals ruled that this violated their religious free exercise rights provided by the First Amendment. The Oregon Supreme Court reversed. Can a state deny unemployment benefits to a worker fired for using prohibited drugs for religious purposes? Undecided. The court instructed the Oregon Supreme Court to determine whether peyote usage for religious purposes is prohibited under Oregon law or only by the employer. The court required this information to consider the constitutionality of the denial of benefits. Jesse Cantwell and his son were Jehovah's Witnesses. They were proselytizing a predominantly Catholic neighborhood in Connecticut. The Cantwells disturbed religious materials by traveling door to door and approaching people on the street. After voluntarily hearing an anti-Roman Catholic message on the Cantwells' portable phonograph, two pedestrians reacted angrily. The Cantwells were subsequently arrested for violating a local ordinance requiring a permit for solicitation and for inciting a breach of peace. Did the solicitation statute or the breach of peace ordinance violate the Cantwells' First Amendment free speech or free exercise rights? Yes, it was a unanimous decision. the court held that while general regulations on solicitation were legitimate, restrictions based on religious grounds were not.
Laws cannot be made that restrict religious beliefs.
The Pennsylvania legislature passed Act 109, which reimbursed non-public religious schools for certain secular educational services. On June 28, 1971, the Supreme Court held that the Act 109 violated the Establishment Clause of the First Amendment. The case was remanded, and on remand, the district court entered an order which permitted the state to reimburse non-public religious schools for services provided before Act 109 was declared unconstitutional. Was it an abuse of a court's discretion to allow payment of allocated funds to non-public religious schools after such allocations were found unconstitutional by the Supreme Court? No, the court held that permitting payment of allocated funds for 1970 through 1971 school year would not substantially undermine constitutional interest at stake.
This case led to the creation of the Lemon Test, a test that determines whether or not state laws regarding funding or creating religious institutions with public money violate the U.S. Constitution.